Hello everyone, I am Dr. Ankita Jain, a management consultant in the field of intellectual property rights. Today we are explaining what is industrial designs. This video is brought to you by Acviss. So to begin with, we'll understand what is industrial designs, how it gets registered and protected in India, and what are the key features before you select an industrial design for your product, and what are going to be the key features of takeaways from this particular session. So when an intellectual property right is used to grant rights of copyright of a product for its aesthetic appearance only, it is called as industrial design of a product. Now this is also very famously known as design patents in some countries such as USA, and this can be regulated separately under different laws as per the territorial requirements of each of the countries. In India, there is a separate law of Industrial Designs Act which regulates the registration and protection of intellectual property right of industrial designs in India. It is governed by the Industrial Designs Act, and this particular act governs all the features of a designing factor of a product that can be mass produced for industrial use, which means that once it gets registered, it gives exclusive rights or grants the creator or applicant all the rights for using the aesthetic and novel appearance of the product in a commercial way. Now it is applicable to products that can be mass produced, which means that it can be manufactured multiple times in a similar manner in an industry format. So if it is not in an industry format, it will then not be applied for under this particular act. It focuses on the appearance and aesthetics of a product only. It completely ignores the quality, functionality or ability for improvement of the product. It is concerned only how the product looks like, what is the appearance of it, aesthetic looks of it, and it is derived from a combination of patents and copyright laws. Now a few examples to which it can be: shape of a bottle, design of a jewelry or clothing, etc. What can be key considerations before going ahead for application of design registrations is that a design must not be purely hypothetical or obvious. For example, a basic geometric shape, etc. It must be applicable for industrial production as well. If at all a design is on paper very much valid, but it does not have any industrial application or a means of industrial production, it will then not be taken forward for registration. How does a industrial design gets registered in India? It is like I mentioned, it is governed by the Industrial Design Act in India. Once it is applied for registration and it gets grant, it gets registration for a duration of 10 years from the date of application, and it can be renewed only for 5 additional years, which means that in totality only 15 years of registration can be acquired for a particular design registration. The design must not be used for before the application. This is a very prerequisite aspect for any industrial design application. The process of registration will take anywhere between 1 year's time to more than that for any application. It gives protection in the legal framework where the Industrial Designs Act in India is taking care of it. In the US, the Patents Act takes care of it. This design, industrial design, is also territorial in nature, which means that the registration is required to be done in each country where the product or is either used or sold or marketed. The rights enforced of industrial designs protects all the rights of the owner against unauthorized manufacturing and enhances brand efficacy and safety of the product. Commercial benefits reaped by the owner or applicant is that it increases the economic value of the licensing, assignment or sale opportunity for a fee or royalty for any of the applicant's commercial transactions. Now we look into the difference between industrial designs, copyrights, patents and trademarks. How does one define what is different in a product when it comes to its industrial designs, trademarks or patents and copyright? So the protection provided here in industrial design is for the novel, aesthetic and ornamental appearance of a product only, or the article of use that is coming in front of you. Whereas when it is patents, it gives protection to inventions or technical enhancement that is new, inventive and useful in nature. And it is governed by the patent law in our country. Whereas copyrights are protecting expression of an idea, and it is governed by the Copyrights Act in India. The trademarks are also protected by a different act, which is called the Trademarks Act, and the protection provided here is for marks representing businesses. The duration of protection provided for each one of them is different from one another. And when we look into industrial design from a business point of view, it contributes a lot to brand building. It has a specific role in creating a brand recognition of its product, as it looks at the outer appearance of the product with stark detailing. Any brand often relies on the combination of several intellectual property rights for better recognition and for maximum utilization for its business growth. Whereas outer appearance of a product is important as well as understood when it comes to trademarks or technology. In case of industrial designs, creative designs contribute to marketability and brand strategy as well. For example, Apple has a product called iPhone, known for its product and packaging designing, because it combines both the factors of functionality with aesthetics while presenting itself. With that, we come to the segment of do's and don'ts of this session. A few do's for industrial design is that every applicant has to ensure that the design applied for is novel and original in nature. It is applicable to functional articles and is also visible on the finished goods and products. It maintains confidentiality until it is registered or applied for registration. And it ensures capability for mass production in totality as well. With that, understanding a few don'ts as well is that every applicant has to avoid public disclosure prior to the application of registration of an industrial design. Every applicant has to avoid obvious designs as well, such as simple geometric shapes as well. And the last one is not focusing solely on the functional ability of the product, but also how the appearance looks from the outset. A few key takeaways from this session is that industrial design protects the visual appearance of the product, making it more appealing, enhancing, adds to the intangible value of the product. It encourages creativity in manufacturing, leading to expanded commercial activities and duplication of product in the manufacturing process as well. It contributes to building brand image and identity through creative designs. Now, if I have to answer a few questions, what is the difference between an industrial design and a utility model? Now, industrial design is basically protecting the aesthetic appearance of a product, whereas utility model is a advanced model of patents, and it protects the functionality of the product or process that is applied for. Industrial design can be applied only for products, whereas utility model can be applied for both product and process as well. The duration of protection granted for industrial design and utility model is very different. The second question is, what role do industrial designs play in an e-commerce marketplace? It plays a humongous role because the product is displayed on the e-commerce platform through its shape and design, and not just by an oral manner where it is being spoken about. Therefore, how the product looks like adds a lot more value to the product as well as the company which is displayed in the marketplaces on e-commerce. How can small businesses leverage industrial design protection? By applying for its registration under the territorial laws that are available where all the products are being sold and marketed. The last question is, what are the steps to enforce industrial design rights in case of infringement? In case of infringement, industrial designs can be protected through registration of its application under the Industrial Designs Act in India, and it can be enforced through civil or criminal route depending on the availability and situational aspect of the case.
Do share your feedback on where we can improve on what we just covered. Thank you.